Thank you for joining eTitle and Orleans PC for today's webinar, Ownership and Realty. My name is Connie Kinzer. It is my pleasure to introduce our esteemed speaker for today, Regina Slowey. Regina is the Managing Litigation Attorney for Orleans PC. Ms. Slowey has over 20 years of litigation experience, specifically devoted to business and real estate litigation involving the mortgage lending and servicing industries. She has also been involved in the title industry for over 15 years, working with realtors, agents, and underwriters. Attorney Slowey manages the title, collection, and litigation areas of practice throughout all Orleans PC jurisdictions. She loves to share her expertise at all training seminars, conferences, and continuing education courses on real property law and related topics. I now turn it over to Regina.
Thank you, Connie. And thank you for joining us today. As Connie mentioned, I have been a real estate attorney forever, and I have a special place in my heart for title, property, and for educating people about what is normally the largest transaction of their lives. Of all the questions I get asked, how people hold real property and what consequences it has is one of the most common. And as realtors, you may get these too. Like my sister and I want to own this together. The title company is asking what to put on the deed. What should we say? Or if I die, what is going to happen to this property? Or my husband and I had 2 credit card judgments filed as liens. Are we going to need to pay them both out of the refinance? And as consumers, we have the same personal questions for our parents, for our children, for ourselves. Understanding the basic principles of how we hold real property is valuable for yourselves and for your clients. Today, we are just going to talk about how ownership vests. Vesting is a term we use that means the way an owner or owners of property take title or ownership to their real estate. Now, an important disclaimer. This webinar is very high level. I could literally talk for hours about each individual topic within this presentation. Property can either be owned individually or concurrently with other owners, and I will give a brief overview of the most common ways to own it. And we will look to those common questions. What limitations are there? What attaches? And what happens if an owner dies? But as I mentioned, the goal of this presentation is to give you an overall understanding of vesting. It is not a replacement for legal advice. Determinations on what is best is always fact specific. So you should talk to a real property attorney in your state whenever you have a question. Ownership is linked part and parcel to the American dream. But ownership is not an absolute guarantee that your intentions are fulfilled. So let's actually start by talking about what affects ownership in general. Homestead property. Homestead property is just that, property which is used as a home. Depending on the state, it is called homestead or principal residence or primary residence. But what it is in effect doing is defining one place where a person has his, her, or their true fixed and permanent home. It was developed as a real property tax credit or exemption, and it offers other protections as well, designed to protect the home for everyone who lives there, particularly from judgment creditors. Florida in particular is what we call a very strong homestead state. The Florida Constitution protects the homestead in Florida, which makes it much harder to change than if it were just a statute. The protection of the Florida homestead is one of the strongest asset protection tools in the country. The law protects unlimited amounts of value in the debtor's Florida home, regardless of how it is owned. This means that judgment creditors cannot attach their liens to homestead property. Michigan does have some primary residence protections as well, but is much more focused on the tax break. So why am I saying this affects ownership? Because the protections do actually curtail certain rights of ownership you might think are a given if you are an owner. For example, if property is homestead property in Florida, you cannot just leave the property to anyone. It is designed to protect the home for the family, including and perhaps especially minor children living there. Now, as we discuss the types of ownership, it's important to remember that the homestead or the primary residence protections extend only to that one true fixed permanent homes. How you own your property, though, goes across any real property you own, your home, investment properties, summer homes, etc. Dower and courtesy. These are now abolished in most states, although we have 3 remaining holdouts in Ohio, Arkansas, and Kentucky. Dower is essentially the right of a wife to claim 1/3 of her husband's estate at her husband's death. Courtesy is the right of a husband to do the same. It's really not needed now, as most states have enacted a probate code which gives the same or greater protection to the surviving spouse. But some vestiges remain, especially because Michigan did not abolish dower until 2017. It's not a concept that should overly concern you, but you should know what the term means, if only to confidently say that it no longer exists. Liens. Liens affect your ownership. The most obvious lien is your mortgage. When you sign that mortgage, you're signing covenants to maintain the property as well as to pay pursuant to the terms of the note. If you fail to pay your mortgage, one of the available remedies to the lender is foreclosure. Outside of mortgages, there are other liens that can also attach to your property. IRS tax liens, judgment liens, real property tax liens, homeowners or condo owners association liens, special assessments, and mechanics or construction liens. These are the most common. And any of these liens have the possibility of attaching to any property. Even in Florida, where the home is protected from so much, including judgment liens, any lien voluntarily given to secure a loan, such as the mortgage to purchase your house, a home equity loan, real property taxes, HOA or COA liens, and construction liens attached to all property, regardless of how held and regardless of whether or not it's a home. And each of these liens retains the ability to foreclose if not paid. And of course, no one messes with the federal government, and so IRS tax liens also attach. Death. Death affects ownership in property. And not to make light of it, but while it may be obvious that the person who died has lost possession or ownership of the property, it's not always obvious who does own it. And it comes back squarely to how it was written on the deed. Many cases exist in which the intention is not the reality, so it really helps to think about that in advance. Our first area of tenancy is sole ownership. Property can obviously be owned either individually or concurrently with other owners. Sole ownership is exactly what it sounds like. A single human or an entity owns the property by itself. The most common is either ownership by one entity or one human being. A trust and an LLC are 2 vehicles that are considered a single entity, and yet may have many beneficiaries. Trusts are becoming very popular to transfer property because in many states it avoids the necessity of opening probate estate to dispose of the property. And it has the additional benefit in many states of avoiding any applicable estate taxes and potentially even uncapping of property taxes. Florida is an exception, as that homestead protection is so strong that if you have a spouse and or minor children, Florida law dictates that you may not transfer your homestead in a will or a trust. If you have no minor children, you may transfer your homestead only to your spouse. Title in this situation is simply vested in John Smith or the family trust of William Marker or White Trees LLC. So what liens can attach? Well, the answer is that any lien can attach if the lien is in the name of the vested owner, but it must be in the name of the owner. So on its face, a judgment against John Smith will not attach to property owned in the name of the family trust. Obviously, a mortgage does attach if granted by the title owner. It would need to be signed by the individual, by the trustee, or by the authorized member of the officer of or an officer of a corporation. For a corporation, the type of corporation, an LLC, an S Corp, a C Corp, etc., determines who needs to sign and what needs to be presented as authorization to sign. Most questions come through, can I own this property on my own? The answer is easy if a man or a woman is not married. It becomes a tad more complicated if they are married. It is okay, you can hold individually if married in most circumstances, although in Florida, it must be non-homestead property. And then comes, who needs to sign documents at closing? Well, if it's owned by an individual human, the individual alone is the only one who needs to be present to sign, unless the property is the marital primary residence, in which case the husband or the wife may need to be present also. If it's by a trust, the trust documents state who can convey property and under what circumstances. So the title company is going to need a certificate of trust in a recordable format that states who may convey and the authority in the document on which that rests. A corporate sale will typically require a resolution or the corporate docs to show who has the authority to decide and to sign the documents. Now, concurrent ownership is much more fun. These types of tenancies are typical across most states and have very definite traits: tenants in common, joint tenants with rights of survivorship, and tenants by the entireties. The best practice is to be very specific with the intention. The deed should state the names of the new owners and how they are taking ownership. For example, to Fred and George as tenants in common, or to Ginny and Hermione as joint tenants with rights of survivorship. It's typical across many states, but there are some very key nuances. Tenancy in common is a shared tenancy in which each holder has a distinct and separately transferable interest. The vesting language can be specific or not. It can say the grantees are Ginny Weasley and Hermione Granger as tenants in common, or it can simply say to Ginny Weasley and Hermione Granger. Either way, it is vested as tenants in common. Tenants in common hails back to common law England, and the basic principles are the same. It is the presumed intention of vesting between two individuals unless the people are actually married. This is the type of ownership that is by default, so to speak. So unless there is other language there, or unless the two owners are married, the law will presume tenants in common. Each tenant in common owns a specified interest in the property that may not necessarily be equal shares. However, the percentage of ownership of each tenant in common may be specified in the deed. That's where you get some of those fun deeds that Ginny owns 50%, Bill, Charlie, Fred, and George, and Ron each own 10% as tenants in common. If the percentages are not specified, it is presumed to be an equal division of ownership, but that can be proven otherwise after the fact. As a practical matter, regardless of percentages, you can't do much with it unless you have 100% agreement. So there's really more of a predetermination of the distribution of profits. Because regardless of the percentage of property, each tenant has the right to possession and the use of the entire property. There are no tape lines down the center of the house, with Ron only getting the bathroom, Fred and George sharing the kitchen. Even if 1% ownership shows the right to use, even 1% of ownership gives the right to use the entire property. There is no right of survivorship. So if one dies, the property passes to that one's heirs or devisees. It does not go into the other shares. So in the above, if Ron, who owned 10% share of the property, dies, that 10% goes to his heirs if he has no will, and his devisees, which is a fancy word for someone left something from a will, if he does have a will. So each person in a tenant of common has what we call that distinct chain of ownership. There's no lien protection. So if a creditor obtains a judgment against one of the owners, the judgment lien can attach to the property, but only for the percentage the individual owns. In other words, if a creditor obtained a judgment against Jenny for $25,000 and properly perfected it so that the lien attached to the real property in her name, it would attach to a 50% interest in that property, which means that if they went to sell, the title company would ask for a payoff. Now, it's also important to note that it can only attach to the amount up to her ownership interest. So, for example, if the judgment lien was for $75,000 and the property sold for $100,000, the judgment creditor would only be entitled to her share, i.e. 50%. In the same vein, though, you can actually mortgage your percentage individually, and people actually do this. Meaning if a property is worth $1 million and Bill is a 10% owner, he can legitimately mortgage his 10% and receive a $50,000 loan. And if Bill does not pay on the terms of that loan, the bank can foreclose, but only on Bill's portion. The other co-tenants' interests are not affected. Now, instead of Bill being a 10% owner with the rest, the successful bidder at the foreclosure sale is. So the next two tenancies are joint tenancy and joint tenancies with rights of survivorship. These are the tenancies that have the widest amount of divergence among the states. In fact, some states don't even have both. Florida and Michigan do have both, but they are very different in each state. However, in both Florida and Michigan, what is written on the deed is the same. To be joint tenants, it must be declared specifically as joint tenants or as joint tenants and not as tenants in common. It's not enough to say jointly. This will actually put you back in tenants in common land. So the example, to Ginny Weasley and Hermione Granger as joint tenants. Now here's where it diverges. In Florida, joint tenants are essentially the same as tenants in common, but they must have the same equal percentage ownership in the property. Ginny and Hermione must both own 50%. But like tenants in common, there is not a survivorship aspect in Florida, which means if Hermione dies, the property does not go to Ginny. It goes to Hermione's heirs or devisees, which means if you want to sell the property after Hermione dies, Ginny needs to sign, but so does the PR of Hermione's estate or the person or people to whom Hermione left the property. That is very different than in a state like Michigan, in which survivorship is presumed. The property cannot be devised, left by will to someone else. So if Hermione dies, Ginny does own the property free and clear. And if she wants to sell, she's the only one who needs to sign. However, there's a couple interesting characteristics in Michigan. First, the interest is subject to creditors, and that's because the tenancy may be severed unilaterally, which then creates tenants in common. That means while they're both alive, Hermione can just sign a quitclaim deed to Fred, and that does give Fred a 50% interest in the property, and it severs the survivorship aspect. If Fred dies, the property will go to his heirs. It will not revert to Ginny. Joint tenancy with rights of survivorship. This is on the other range from tenants in common, because for this, the owners have agreed at the time they're taking title that they are taking it with the intention that upon death, it revert to the other owner in full. An express declaration of joint tenancy with rights of survivorship is required. The word or a form of the word survivor must be included. The most common are joint tenants with rights of survivorship or joint tenants with full rights of survivorship. So here we say the property is conveyed to Bill and Charlie as joint tenants with rights of survivorship. Now here is where it gets crazy and why, quite frankly, you should always have an attorney who is well versed in the real property law of the state where the property is to review your documents. In Michigan and Florida, joint tenants with rights of survivorship are very different. In Florida, joint tenants with the rights of survivorship is essentially the same thing as Michigan's joint tenants. So this is going to sound familiar. First, survivorship is presumed. The property cannot be left in a will to someone else, but the tenancy may be severed unilaterally, which then creates tenants in common. Often it's severed unintentionally by attempting to bring in a spouse or by one owner conveying a mortgage interest unilaterally. So if mom and dad leave their house to brothers Bill and Charlie, and Bill later signs a deed on his own because he wants his share to go to himself and his wife, Bill just busted that joint tenancy, and the property is now owned by Charlie, Bill, and Bill's wife as tenants in common, which means if Bill dies, his shares go to his share goes to his heirs. Nothing reverts to Charlie. Also, if one person mortgages his interest, that also severs the tenancy, and the result is a tenants in common. However, in Michigan, there is a very real difference. The parties cannot unilaterally sever. It can only be destroyed by an act of all the parties, meaning essentially all joint tenants must sign a deed to change it, either selling the property or creating a different tenancy. In our example, in which Bill and Charlie own the property as joint tenants with rights of survivorship, if Bill executes a deed to himself and his wife, he is not destroying the survivorship aspect. What he's doing is giving his wife access to his own rights to the property for the duration of Bill's lifetime. If Bill dies, his wife no longer has an interest in the property, and the property is owned by Charlie alone. When Charlie dies, the property goes to Charlie's heirs only, not to Bill's. And to mortgage the property, all joint tenants must be in accord and all must sign. And judgment liens here can attach, but they're difficult to enforce, and they're not against the whole property. It may be possible to force a sale, but typically only the federal government for federal tax liens is that motivated. And if the owner with a judgment dies first, there's nothing left to which the judgment can attach, and the property is not encumbered. Tenancy by the entireties. It's similar to joint tenants with rights of survivorship, but it is stronger. It is the presumed form of ownership when a couple who is married takes title to the property, regardless of whether it states it on the deed. So even if it says nothing to Arthur Weasley and Molly Weasley, they will receive entireties protection in the property. And the entireties protection is pretty great. Protection from judgment creditors, assuming it's against only one spouse, absolute right of survivorship that cannot be severed involuntarily. There are many ways to note this, and on the deed after the names, it should read husband and wife, his spouse, married to each other, or as a married couple. You may have noticed that non-gender specific denominations are becoming standard. This is because of a 2015 Supreme Court of the United States decision, Obergefell v. Hodges, in which the Supreme Court ruled that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment, which meant that all states must recognize the marriages of same-sex couples on the same terms and conditions as the marriages of opposite-sex couples, with all of the accompanying rights and responsibilities, which for us means they must be afforded the protections of tenancies by the entireties. And yet our traditional terms of marriage are decidedly bent towards male and female unions. So all of a sudden the phrase as a married couple became a gender neutral indicator for real estate conveyances. And there are so many things in real property that hail back centuries that this was quite the shakeup for the title world. And it is good for us every once in a while to reassess. There are specific characteristics of property owned by a married couple. First, in order to get it, a valid marriage must exist at the time that the estate is created. Subsequent marriage does not create it, even if it's already in both names. So if Jack and Jill were not married and they purchased a house together as joint tenants or tenants in common, after they married, they would need to execute a deed from themselves to themselves as a married couple to hold the property as tenants by entireties. Entireties is typically owned as one unit if it's part of tenants in common or a joint tenancy. The married couple essentially becomes one legal entity here, and one spouse cannot impair the rights of the other. So there's no creditor attachment, because if the judgment is just against Molly, it doesn't attach to that entireties entity. From the standpoint of asset protection planning, there's a high degree of protection here. A judgment of one part of the couple cannot attach to property owned by the union. Additionally, at the death of one spouse, the property automatically passes to the other without the need of an estate being open, without any formal proceeding at all. The property is now by operation of law owned by the surviving spouse. And if the survivor wishes to mortgage or sell the property, only the death certificate is needed. However, at this point, individual debts of the survivor will automatically attach to the property. And likewise, at divorce, it converts to tenants in common immediately at the time the order is entered by operation of law. So if you get a divorce, that marital union no longer exists, and the property is now automatically held as tenants in common by the couple who used to be married. And all individual judgments may now attach on each person's interest individually. So that brings us to the end. Those are the basic ways to hold property. I know we have some questions coming through though, so fire away.
We do have a few questions for you today, Regina. The most popular question we received was the following. Regarding the joint tenant discussion, is it possible that one of the tenants could deed the property to someone else without the remaining tenant knowing about it? And if that's the case, what can be done about it after the fact?
Okay, so the answer to this is yes, for joint tenants or joint tenants with rights of survivorship. Quick note, that's not true for tenants by the entirety, but in a joint tenancy situation, one owner can unilaterally act without the knowledge or the permission of the other. The effects are different depending on the state that you're in. But the fact remains that you can all of a sudden be sharing ownership in a way or with a person that you completely did not intend. Your co-owner doesn't need your permission to do this. But now, if you really cannot handle the new co-owner, or if you feel there's a reason they're destroying the property, there are lawsuits you can start to prevent the waste or to force the sale of the property so that you are out of it and you get your equity and you go on with your daily life. But this shows that you need to be careful who you choose to own property with. It's essentially a partnership, and you have to have the rules in mind when you're obtaining that property.
Another frequently asked question is, how do I know which option is best for me?
Well, that is going to depend on your end goal and where your property is. Who do you want this property to go to? How long are you planning on owning it? Is it a quick investment flip? You may want an LLC or a family beach house that you want your children to enjoy without going through probate. You might want to think about a family trust. Is it somewhere in between where you and your spouse have decided to enjoy and sell off to fund your retirement? Your end purpose is what's important to consider when deciding what to write on that deed. And to get to your end purpose, you should really speak with a real property attorney in the state in which the property rests.
And our final question today is, which option offers the greatest protection from creditors?
Well, hands down, tenancies by the entireties. The tenancy by the entireties treats a marital couple as one in the eyes of the law. And as such, when the property is held that way, an individual spouse can't voluntarily or involuntarily alienate or sell or allow liens to attach to the property without the consent of the other spouse. So in other words, one spouse can't dispose of any part of the estate without the consent of the other. And you can't subject to the property to the payment of your individual debts. So yes, the debts directly connected to the property stay with it, like your mortgage, your real property taxes, etc. And the IRS is never going to back down. But outside of that, your individual debts will not attach. It is your strongest ownership tenancy. Note, though, that it does dissolve automatically upon death or divorce. So it needs to be considered as a piece of a bigger estate or asset protection plan.
Thank you, Regina. Thank you, everyone, for attending today's webinar. We hope you have a great day.